Hello, and welcome to Williams-Mullen's Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, and today I'll be joined by Amanda Weaver, a senior associate in our labor, employment, and immigration practice, to discuss some new Department of Labor regulations regarding independent contractor classification. How are you doing today, Amanda?
I'm great. How you doing, Brydon?
Doing well. Thanks for coming on to the Benefits Companion.
Yeah, absolutely.
So I understand that right at the beginning of this year, the Department of Labor issued a final rule determining whether a worker is an employee or an independent contractor. Why is it important for employers to identify whether a worker is an employee of the company or an independent contractor?
Well, it's very important. And I think a lot of people are aware of there's different terms for whether someone is treated as an employee or an independent contractor. You'll hear employers throw around whether someone is quote unquote W-2 or 1099, meaning how they're paid for tax purposes. But going back many years, there has been an enforcement efforts on both a state and federal level to try to identify employers that are misclassifying workers who should be employees, W-2 employees, as independent contractors or 1099s. And there's a big difference. An independent contractor, someone who can appropriately be paid as a 1099 for tax purposes, is really meant to be someone who is operates their own business, is independent from the business of the company or the employer, and thus, they're not entitled to many of the same benefits and protections as an employee. So obviously there are some, very palpable financial implications of whether someone is an employee or an independent contractor. An employer is obligated to withhold federal income taxes and other federal taxes from their wages, any applicable state income taxes. They're required to pay for required benefits like unemployment insurance and payroll taxes for employees that they're not required to withhold for independent contractors. But beyond that, there are protections for employees under the law, like anti-discrimination, anti-retaliation, disability accommodation protections that independent contractors are not entitled to. So there are a lot of reasons why there's an interest in making sure employees that should be treated as employees aren't being misclassified as independent contractors.
Yeah, it's really a hot topic in employee benefits, because if an individual is an employee, then they may be eligible for the employee benefit plans that the employer sponsors. And often in our plans, we will define an eligible employee as a person who is classified by the employer as a common law employee, even if a government agency or court determines that the person is actually not an independent contractor. So it's important for employee benefit eligibility purposes and non-discrimination rules as well in the employment area to know whether someone is an employee or an independent contractor. So what does the new Department of Labor final rule provide?
The new rule is interesting in a lot of ways. First, because the Department of Labor hasn't issued a rule on this on an independent contractor classification before. They've issued guidance, but they've never actually engaged in formal rulemaking to set forth a DOL mandated test for how to determine whether an employee is an independent contractor or a worker is an independent contractor or an employee. So it's interesting in that way. And what's also interesting about it is that it actually is a little bit more flexible than some of the other tests that are floating around, and it's probably worthwhile to say here that there are many tests. Again, the determination of whether someone is an employee or an independent contractor has been a hot topic of conversation for a long time. So the IRS has a test that it uses. States have their own tests that they use, and there are various iterations of what factors are going to be considered by a court or an agency when they're looking at whether a worker is an employee or not. This rule is actually a little bit more relaxed compared to even what the DOL has said in the past. The test for independent contractor status one of the tests anyways, has commonly been referred to as the economic realities test. And what that means is there's a list of factors that you look at to determine whether, in economic reality, the worker is economically dependent on the company or whether they are sufficiently independent to be an independent contractor. And the new rule is a variation of the economic realities test, but it's a little bit different in that instead of setting forth 5 or 6 or 20 factors that each have equal weight to be reviewed and in total to determine whether someone ultimately falls as an independent contractor or an employee, the DOL has, in this rule, has sort of compressed it down to 2 main factors that it is actually giving more weight to. And those factors are whether the worker or the nature and degree of control over the work that this worker is performing and the opportunity for profit or loss based on the worker's own initiative. And so these are not new factors. These are factors that have been part of virtually every test that other states and agencies have imposed. But the focus on these 2 factors as being the most significant is what's different and new about this rule. And the DOL goes on to say that, if you look at those 2 factors and they don't point to one consistent classification, whether that's they both consistently point to and that the worker is an independent contractor or they're both consistent with an employee relationship, then there are a couple of other factors that you could then turn to try to break the tie, so to speak. But because we're focusing on these 2 factors, it means that if they indicate or arguably indicate an independent contractor relationship, then under this test, you can almost stop there and say, okay, this worker is an independent contractor, and you don't have to analyze a bunch of other factors and try to determine on the whole whether the worker can appropriately be treated as an independent contractor.
Yeah, that's interesting. The concepts are really similar to the IRS test, except for what you're saying here is the emphasis on 2 factors that you look at, and then you look at the other factors only to break the tie. That's an interesting change with the Department of Labor's rule.
And I think once you actually dive into it in practice, which of course we haven't had a chance to experience and we may never have a chance to experience, I don't think it would end up being all that different, because the idea of how much the employer or the purported employer controls the work has always been a very primary focus of any test. And there are many factors that sort of fall under that factor. So I have a feeling that in practice it wouldn't end up looking all that much different, but it certainly seems intentional that the purpose of this rule was to simplify and add some flexibility to the determination.
Amanda, one of the things I often see with clients is they'll have an independent contractor agreement, and they'll point to that and say, well, they want to make sure that these workers are not treated as employees. So they get them to sign an agreement where they agree that they're not employees and that they actually are an independent contractor. How do those agreements fit into this regulatory scheme?
That's a great question. They are, to the dismay of many employers, they're not determinative in and of themselves. So an independent contractor agreement can be helpful. It's certainly nice to have something in writing that is consistent with the way you want the relationship to be interpreted. You certainly don't want to have an employment agreement with someone that you're calling an independent contractor, obviously. But if you have an independent contractor agreement with a worker, but everything about the actual functioning of the relationship in practice points to an employment relationship under whether it's this new test that the DOL has come up with or any other test, the actual realities of the relationship are going to control over the independent contractor agreement. So in short, you can't contract around the realities of the relationship. A court or an agency that's reviewing this determination is still going to look at the ins and outs of the day-to-day working relationship between the company and the worker.
Right, and that's, I guess an agreement saying that someone's an independent contractor would not be determinative, but as you said, you definitely don't want an employment agreement with someone who you want to be a contractor. So really the absence of an employment agreement is good if you want the worker to be an independent contractor.
Right. And we'll certainly have situations where we made a business decision to classify someone as an independent contractor and understand that there might be some parts of the relationship that weigh in favor of employee, some parts that weigh in favor of independent contractor. We're not exactly sure where it would come out, but we want everything to be as consistent with an independent contractor relationship as it can be. And in that case, we would certainly, we'd want an independent contractor agreement. We'd want to make sure that that agreement didn't include provisions that looked like an employee. And then we want to make sure, most importantly, in practice, that the relationship was consistent with the independent contractor agreement and what an independent contractor should be in practice. So there's definitely a place for, and there's a value to an independent contractor agreement. I think the misconception is that if you have one, you're good to go, and that's not true.
How do these new regulations impact the new Virginia legislation that went into effect in July regarding worker classification?
So the short answer is they don't, at least not on the state level. The new rule, which I suppose we should say it doesn't take effect until March. The new DOL rule takes effect March 8th of this year, and I'm sure we'll touch on this, but there's reason to believe it will never take effect. But assuming that it does, it leaves discretion to states to impose more stringent or different tests for determining worker classification. So Virginia is one of those states as of last year in July that has put in place a particular test for worker misclassification for state purposes. And Virginia actually, by the statute you mentioned, Virginia follows the IRS test, which is a 20-factor test. And I won't go into every one of those factors, but it's definitely more of the old school test where you have a laundry list of different factors to consider whether someone is an employee or an independent contractor, and you have to look at the totality of the factors and decide whether someone can appropriately be treated as an independent contractor.
So again, when do these regulations go into effect?
The rule takes effect March 8th, but now that we have a new administration and President Biden has indicated he's in favor of much more strict independent contractor classification rule, we can expect that it's likely that some action will be taken to halt this new rule going into effect.
Okay, well, Amanda, thank you so much for coming on to the Benefits Companion. This is a very interesting and helpful discussion for employers.
Absolutely. Thanks for having me.
If listeners have any questions or suggestions for future episodes, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.